The Golden State recently passed the California CARS Act, which largely mimics the FTC CARS Rule the Fifth Circuit Court of Appeals overturned earlier this year. Let's talk about what it means for California dealerships and what it might mean for the rest of the country. As soon as the Fifth Circuit overturned the FTC CARS Rule, the California Senate introduced SB 766, the California CARS Act. Like the federal version, CARS was an acronym for Combating Auto Retail Scams, gratuitously implying all car dealers are scam artists. In addition to the Act's title, the California CARS Act largely tracked the federal version. One element even California wouldn't include from the federal CARS rule was the definition of express informed consent. This eliminates one of the most onerous requirements of the original. But one element California did include was the concept of total price. Total price means the total sale price of a vehicle, excluding only taxes, government fees, and certain narrowly defined charges. Total price includes any dealer price adjustment and the cost of any item installed on the vehicle at the time it is advertised, and does not include any deduction for a rebate. What all this means for California dealers is that the featured top-line price in an ad for a specific vehicle must be the nearly all-in price, including dealer or document fee, delivery charges, and any preloads or charges set forth in an addendum sticker. To prove compliance, dealers must retain records of their advertisements that mention total price or any finance terms for a period of 2 years. The definition of advertisement includes all internet-based listings. So if you're a California dealer that doesn't retain archived copies of every vehicle listing on your website, you'll need to start. In addition, the total price must be disclosed in the first written communication between a dealer and a consumer that references a specific vehicle. The dealer must keep a copy of that written communication for at least 2 years, and the dealer must provide a copy of that communication to the consumer upon written request. In short, separately listed document fees, preloads, and delivery charges will be a thing of the past in California when its CARS Act goes into effect on October 1st, 2026. Another significant part of the California Act is that it requires dealers to give customers that purchase a used vehicle for less than $50,000 a 3-day right to cancel. Dealers may charge a limited restocking fee in the event a customer returns a vehicle, but I doubt that will make the dealer whole. And will this stretch CIT by 3 days? Probably. I can't see a bank buying paper and advancing funds unless it knows there won't be an immediate cancellation. Voluntary protection products, or add-ons as California calls them, must clearly and conspicuously state that they are optional. This may require changes to both the product contracts themselves and the forms documenting the vehicle transaction. Again, the California CARS Act doesn't go into effect until October 1st, 2026, but these are things to be aware of. What does all this mean for the rest of the nation? Deep blue states may copy this legislation in the short term, and even red states may follow suit with time. Let's see how this law works in practice, and if it really delivers on its promises to reduce fraud and lower costs. Mosaic is developing content to train its California clients on the impact of the CARS Act, as well as many other California-specific rules. Contact me or stop by our booth at NADA 2026 in Las Vegas and ask us about it. We've got you covered. For Drop the Bow Tie, I'm Jim Ganther. Thanks for watching.